What would you do if your neighbor drove a massive 32-foot cargo trailer directly across your property line and parked it there like it was a municipal parking lot? No permission was ever given to them. There was no friendly knock on the door, and absolutely no acknowledgement that I even existed. When I walked over and politely told her that was my private land, she looked me dead in the eye. She just smiled coldly and said, "Prove it." What happened over the next 4 months cost her nearly $6,000 in total fines, a forced commercial tow, and a formal HOA censure on her public record. Every single consequence she faced came strictly from professional paperwork, not from toxic confrontation. Welcome back to Ho Drama Neighbor, the channel where homeowners stand up and fight back. I own the corner lot located right at the end of West Haven Court, which is a quiet suburban cul-de-sac in Columbus, Ohio. I have the official property survey map framed clearly on my garage wall. It is not there as a decoration, but as a constant reminder of exactly what I own out here. It shows exactly where my legal rights begin and where they end when dealing with entitled neighbors. One day, my neighbor Amber purchased a massive trailer. This was not a small utility trailer at all, but a full-sized, enclosed, dual-axle cargo trailer used by commercial contractors to haul gear. The entire trailer was sitting directly on my manicured lawn area. The rear axle of the vehicle was sitting a full 4 feet past my boundary marker, so I immediately went and knocked on her door. Amber answered the front door quickly, looking like she had been watching me from a front window. I pointed out the encroachment, but she scoffed and said, "It is barely over the line, that's all." Then she arrogantly said, "It is fine," and slammed the door right in my face. I immediately photographed the massive trailer on my grass from several clear angles to build my case file early. I also photographed the exact position of the boundary marker. I emailed all of these digital files to myself with a secure timestamp to preserve the evidence. Section 7.4 was crystal clear. The bylaws state that no vehicle or trailer may be parked on any lot other than the owner's without written permission. I drafted a polite, formal written notice to Amber regarding the violation. I printed the document, signed it properly, photographed it for my records, and hand-delivered it straight to her mailbox. On day 6, I submitted a formal complaint to the HOA management. I attached the certified survey, the clear photographs, and every single timestamp. Soon after, I found an annoying handwritten note tucked tightly under my front windshield wiper blade. The note was written in Amber's messy handwriting and stated, "This isn't over." I calmly photographed the written threat, dated it, and added it to my growing property encroachment file. Next, I contacted a licensed land surveyor to establish indisputable facts. The professional surveyor came out on a Tuesday morning and drove heavy stakes into the ground at both property corners. The official measurements proved the rear axle of her cargo trailer was exactly 4.2 feet past my legal line. Amber tried to argue against it by citing something she called historic use allowance. She even claimed an implied easement existed on my land. My real estate attorney reviewed her wild claims in about 4 minutes and wrote back stating, "There is no recorded easement here." He confirmed her legal letter was entirely without merit. I now possessed a certified survey, a formal HOA complaint, a handwritten threat, and a solid legal opinion letter from my attorney. The highly anticipated HOA board meeting finally arrived. I showed up dressed in a clean collared shirt, carrying a neat printed folder containing a full chronological evidence packet inside. Amber also showed up to the meeting. She came alongside her cousin, who wore a formal jacket with a small HOA logo pin from whatever random community board he had previously served on in the past. I placed my professional evidence folder on the podium. I did not raise my voice a single time. I simply walked the board members through 7 distinct exhibits in a matter of 4 minutes. I showed them the certified land survey with the 4.2-foot trailer encroachment clearly marked in bright red ink. The board president, Wayne, looked over the evidence packets very carefully. Wayne stood up and said, "The board finds the documentation conclusive. The motion to penalize her passed with a 4-1 vote. Amber was immediately issued a formal written board censure. She was hit with fines of $75 per day, which were made fully retroactive to day 11 of the encroachment. She was given a strict correction deadline of exactly 7 calendar days to clear it. The board officially denied her desperate appeal on Monday. But I did not stop there, because the local county has its own strict ordinances. County Code Section 18.44 protects landowners. This specific code allows the private property owner to designate their land as an active tow zone. I called 3 local towing companies to find the best option for the removal process. I went with Central Ohio Vehicle Recovery. They walked me through the legal agreement, and I signed it. They provided me with a county-compliant posted notice sign to put on my property. The sign clearly read, "Private Property, Tow Zone, Authorized Vehicles subject to immediate removal." I gave Amber exactly 24 hours of notice as a final neighborly courtesy out there. Then I called the towing company back. On a Thursday morning at approximately 9:15 a.m., a massive flatbed tow truck pulled up to West Haven Court to clear out the illegal cargo trailer. The experienced driver hooked up her heavy trailer in just 11 minutes. Amber came running out of her house wearing a bright bathrobe. She was screaming and yelling at the top of her lungs. She pointed aggressively at me. Then she pointed at the truck driver, demanding that he stop the process immediately. He calmly handed her the official authorization paperwork on the spot. The driver pointed directly to the posted sign on my property and continued loading the vehicle. The illegal cargo trailer was completely gone from my private yard by 9:30 that morning. The retroactive HOA fines calculated from day 11 through the day the trailer was formally towed away totaled $3,075. The board successfully collected every penny through the lien process. I never once had to raise my voice during this entire ordeal. I documented everything. I filed the paperwork properly, and I cited the law. The law did exactly what it was designed to do. Make sure to protect your boundaries and stand your ground against toxic neighbor overreach out there. Hit that subscribe button right now to support our growing community for more updates. Subscribe to Ho Drama Neighbor for more.